Judge, we have Leslie Odell. We do not have defendant Robert Keach, and this is a case that we did not have a proof of service on.
Okay.
Leslie, please unmute. Calling case 2016-3590 DS, Leslie Odell versus Robert Keach. Today is Monday, November 18th, 2024 at 10:46 a.m.
Okay, Ms. Odell, this matters before the court on your objection to the referee order. I've looked over a lot of the orders in this case from prior orders in this particular matter. And first thing I note is in this file, you had not filed a proof of service showing that you served the defendant. Did you serve the defendant?
Yes, he got the letter because he messaged me about it.
Okay, that's not what I'm asking. He can message you. He can do anything he wants.
I served him. Here's the proof. I asked the court if they needed this proof, and they said no.
No, the court, you always have to file a proof of service showing you're serving the pleadings in this matter. So
I had a signed copy from the clerk that I served it.
okay, that signed, why would you get a signed copy from the clerk? That doesn't mean anything. The clerk didn't sign it, so I don't know what you're saying.
I don't know. They said to send it certified mail. Here's my receipt from the certified mail. I'm not sure what else you want, Your Honor.
A proof of service. There's something called a proof of service that shows that you served it. You basically swear to that before a notary, and that's what the court is looking for.
I have this piece of paper that says objection to referee's recommended order. The lady said, fill all this out, go to the post office, send it certified mail. I did that. I came back to the courthouse, to the clerk's office, and she said, okay, and gave me a date.
Okay, but there's no proof of service. So from the standpoint of the file, we don't know that there's been service because you haven't filed a proof of service confirming that there was service.
They never gave me anything else to fill out.
They don't have to give you that. When you represent yourself, you have to file the same paperwork as if an attorney would if the attorney was filing the case. And one of those things you have to do is file a proof of service showing that there was service on the other party. So what I'm going to do is, obviously we don't have the defendant here, so I don't know if the defendant was served or not. And the file doesn't establish that he was served. So I can't just assume that he was served. So what I'm going to do is I'm going to have you put this matter over. You're going to have to renotice the matter, giving him sufficient notice, and then file a proof of service. And you can get on MichiganLegalHelp.org or any number of online services that simply would have the pleadings that you need to file as far as a proof of service, establishing that there was service. That way, when we grant any relief, we know that the other party did get notice of that. So
okay, so this all started because I went down after getting a letter in the mail.
Okay, I don't need to know any of that information. You need to get a new
I'm just trying to find out why it's $3 a month for the payment.
Again, I'm not getting the specifics because we don't have service, ma'am. And when we have service, then we'll be able to get into the specifics of what happened and why it occurred. I look back
Can I
to
ask
the
a
file.
question?
Go ahead.
I'm sorry for interrupting. How would I find out what happened at the last show cause hearing?
You can get a transcript. You can order a transcript, and that will be the entire proceedings.
Okay.
Okay. We're at this point, the court will just set this matter over. You can renotice it and get service on the defendant, and then we'll address it at that time. Okay. Have a good day, ma'am.